Hi, my name's Jethro. I'm the director of Shine, and in this video I'm going to tell you about the LightSpeed patent package, which can get your patent allowed at a patent office in as quick as 2 months or even quicker, and save you vast amounts of money over what you would have to pay a patent attorney or a patent agent to do this. This service is totally unique. It's not available anywhere else, and it does certain very clever things which leverage the first 2 steps of the PerfectPatent solution. So right now you're on step 3 of the PerfectPatent solution, the LightSpeed patent package, which is all about getting your non-provisional filed at the patent office and getting you a patent allowed, or getting your patent claims allowed at the patent office. If you haven't seen step 1 and step 2, the Perfect Patent Search and the Perfect Pending package, depending on where you're watching this, I'll either include links on the screen or below this, and it's really worth checking out how this whole thing works. But I would imagine if you come here first, you really want to see what this LightSpeed patent package is all about. Is it really as good as it says? So let me explain this to you. When I learned how to patent, I found things out that it seems very few people knew about. Firstly, I found out when I realized I was going to have to do this myself, I found out about what's called a provisional patent application. And at that point in time, there was no microentity status reductions, but it only cost $70 to get patent pending via filing a provisional at the USPTO website. So that sounded great. I then realized that the UK Patent Office, we can actually do the equivalent absolutely free. So that was then a huge step for me, where I realized I could get into the patenting system without actually having to pay any money at all. But more importantly than that, it allowed me to start using the UK Patent Office and start drafting, filing and prosecuting patent applications to grant, which I did with my first invention, dish shine, at the UK Patent Office very, very quickly. And it became clear to me that the UK Patent Office has these incredible advantages. One, it's an incredibly high quality patent office. The quality of the people who work there is very high. Secondly, the customer service, if you can call it that, is incredibly high. There's just very qualified people who are very helpful, and it's just an amazing patent office in that way. But the really incredible thing about the patent office was, one, the saving in fees. They don't charge you the extra fees you get charged at the USPTO as you go through prosecution, but also the speed. You can ask for acceleration and get your first search and examination report at the UK Patent Office in a standard acceleration time frame of 2 months. In other words, a matter of weeks, 8 weeks. To give you an idea of this, at the USPTO, if you file at the USPTO, the standard timelines for you to get your first search and examination report, where you're going to find out whether your claims or your invention concept is patentable, is somewhere between 18 months to 3 years. In fact, it can be more than 3 years. It just depends what category your invention falls under. They just have a huge backlog of applications there. So it can take almost forever. It takes just years. This is a real problem for you, because by that time, your 12 months patent pending status from your first application, maybe your US provisional, has totally gone. Right, so at this point, your patent application, not only that, but after another 6 months after that, usually 18 months after your first application is filed, if you file a non-provisional, your non-provisional will be published 18 months from that first application, let's say your provisional. So your application will have been published as well, and this makes you quite naked and vulnerable, especially in terms of patent offices other than the USPTO, because your own publication of your application, if you then realize you've made mistakes, your own published application can or will count as prior art against you in pretty much every patent office apart from the USPTO, where they have more laid back rules on this. So you really want to get feedback on patentability very, very quickly. And when I learned how to this whole process, the UK Patent Office, which is called the UK IPO, the UK IPO is the equivalent of the USPTO in the US. So the UK IPO was very important to me because it allowed me to get into this with very little cost and get extremely quick patent office results, so extremely quick prosecution. And also, as we go through the process of getting results and going to and fro with the examiner, there's not the extra costs associated with the USPTO. So I have a lot to thank the UK Patent Office for allowing me or facilitating me in getting very good or becoming an elite patent specialist. It was really because of them. If I'd been based in the USPTO, I'd probably still be waiting for my reports now, from 2010. Maybe that's a bit of an exaggeration, but you get what I mean. So from your point of view, not only do I have to thank them, but you also have to thank them as well, because I'm now bringing services to this industry which otherwise weren't available, and that's all leveraged on the skill set I built up mostly through the UK IPO. I've also had patents going to the USPTO as well, and I'm about to go internationally and start filing EPO, PCT applications, etc. So what we're doing here is we're leveraging the quickness, the speed, quality and effectiveness of the UK Patent Office. The British we're not the best at everything in the world. We did invent quite a lot of stuff. A lot of the sports in the world, a lot of the stuff was invented in England or Scotland or in Britain. But there is something which the British mind is still very good at, and that's in terms of clinical effectiveness. We still have some of the best surgeons in the world. We've got arguably the best or one of the best elite kind of army, I don't even know what the technical term is, but you know, the SAS. We've still got very elite troops. And at the elite level, the British still tend to have something, and it tends to come down to the ability to both be creative, to think on the spot, and also to be very effective in your thinking, very effective clinical thinking. We're very lucky at the UK Patent Office that the examiners tend to be exactly that. They're very clinically adept, and you tend to get very professional results, and also very quick. So what we're going to do, we're going to leverage step 2, the perfect pending package, where we filed your application as a provisional, but secretly, without telling you, effectively what I've given you with that provisional is something which conforms to non-provisional standards. So that application is good to go to be filed as a non-provisional. If there's any issues, by the way, with the drawings, I haven't quite decided with the perfect pending package how I'm going to do the drawings, whether I'm going to include one drawing as part of that service just to make sure everything's as it should be, or whether these drawings are going to be done by you. Don't worry about that, because one thing you need to know about me, firstly, I care very heavily about your situation. I care about providing incredibly important services to inventors like you, but I also am very conscientious that I never want any errors or problems to happen for you, because I would consider that a problem that, you know, that shouldn't have happened, that I need to take care of. So I build systems to make sure that can't happen. So that application, allied to the claims in the abstract, which I will have drafted back then in step 2, can be filed as a non-provisional. That's what we're going to do. Whether you're based in the US, UK, wherever you are, you're going to leverage the power, speed and effectiveness of the UK Patent Office, the UK IPO. I will be effectively filing that application for you. Before that happens, let me explain what we're going to do. A couple of things need to happen, especially if you filed your application as a provisional. I need to make a few minor amendments to make sure this conforms to UK Patent Office standards. This will usually include some little tweaks and amendments into the description without really changing the description, because we want things to be pretty much exactly the same. Little structural aspects, which I will do. Also, I have to get your a special document which we're going to file with your application, which is called a request for accelerated search and examination. This is the document which, if accepted by the UK IPO, will mean that they will go ahead and search and examine your application in 2 months, which is really incredibly quick. Imagine getting that feedback from a patent office so quickly as to whether you can patent your invention. Very, very important from your point of view. My experience is a lot of patent attorneys, patent agents, for some reason don't realize how important it is for you to get that feedback as quickly as possible. Maybe because I'm an inventor myself and I learnt this skill set from being an inventor, which is unusual in this industry. I realize for you, the inventor, you really need that feedback ASAP, because that's going to define the results that come back, whether they show you can patent your invention or not, are going to define, for example, whether you're going to try to get worldwide patent protection. Are you then going to go for US patent protection, or then for European patent protection, or even PCT application to try to go through India, Japan, China? That's much more advanced, but in some cases it might be relevant. You need the feedback results so that you can know, if the results come back great, showing you're probably going to be able to patent this, that's going to be a big indicator in your mind that you need to start thinking about putting money aside and committing to those other territories to get a patent in. Whereas if you go through the normal USPTO procedure with a US patent attorney, you're not going to get your results until your patent application is published. And if things go wrong, or something wasn't done right, that could blow your chances of international protection anyway. And the timeline by then will have expired, by which to go for international protection or PCT application, European protection anyway. So this is of real key importance to you as an inventor, and I understand that because I'm an inventor myself. So, to get that underway and get my amendments done and get this document drafted up, which I'll have to do for accelerated search and examination, you'll put in the first payment. At the moment, that first payment is only $400. So compared to the thousands you pay at a patent attorney, we're talking, in some cases, a tenth of the price which you would normally pay. This is opening up all kinds of possibilities for you right here. So I will then get everything ready, and then I'll contact you and show you what I've done, and just check you're happy with it, and that will probably be the case. Once everything is as it should be and we're happy with everything, we've discussed everything, payment 2 will then have to be made. Payment 2 at the moment is $377. So in total, you're only paying $777 in fees to myself, i.e. Shine Enterprise. Again, in many cases, that's a tenth of what you would pay a patent attorney. And remember, this is an elite service you're getting. The claims are drafted by me, and it's an area that I specialize in. So you're getting elite level quality. I don't want you to think there's a big sacrifice in quality here. So that will then initiate the next phase, where I will initiate the whole thing and I will file this. This will be filed in the UK Patent Office, and I will file the application myself and act as agent in terms of this application. That's important from your point of view, because in the UK Patent Office, the way it works, you will need someone, if you're in the US, you will need someone like me who has a UK address or address in a particular area, because the UK Patent Office will not allow people who have a US address. It's a requirement to have an address in certain areas. So you will need to leverage that from Shine Enterprise. So that gets us into the process, and within about 3 weeks after filing, we'll hear from the Patent Office. They'll send a letter usually through to me, and they will confirm or not whether your acceleration is allowed. Providing their requirements have been met, and their requirements are very likely to be met with your application for reasons I'll tell you about when we speak. I won't go into that in this video. So it's very likely their requirements will be met, and if so, you'll get confirmation that the time frame will be about 2 months from your initial filing date. It's not 2 months from that 3 weeks in, it's 2 months from the initial filing date, which is great from your point of view. So then we're playing the waiting game. And you'll know the estimated date we get things back. And when I get the results back again, they'll be sent to me. And they'll be sent to me in a form that you probably wouldn't understand, but I'm very familiar with because I've drafted, filed and prosecuted multiple, patents to grant at the UK Patent Office. And when I get the results through, I'll look at them and I'll check what they mean. I'll get a very, very good idea usually straight away of what's going on. Sometimes it will require more work. If it requires huge analysis, we might have to talk about that because there's a limit to what I can provide for these amazing prices. The other thing I wanted to say is, although the price I quoted in this video, that could change at any point, and it really wouldn't surprise me if that price goes up because it is unbelievable what's being provided. In terms of step 1, step 2, and step 3 of the PerfectPatent solution, you're going to pay a vast amount less than you would pay for just one non-provisional being drafted, filed, and prosecuted by a patent attorney. And the PerfectPatent solution includes, a very high quality patent search service, then getting you patent pending, and then the non-provisional being filed. So you're getting more for a lot less. So these prices may change, and please do not think that I'm held to these prices. When the results come back, as I said, I'll check what they mean. I'll get a very good idea. I'll look through the results, and if prior art has been found, that's where you get the benefit of my skills, because probably one of my areas I'm most able in when it comes to patenting is finding a way through the prior art creatively, not just technically, but creatively. You need both with this area of patenting to get you the best patent protection possible. I will then tell you exactly where you stand, make you aware of where you are, and you can then decide what you want to do. But the truth is, the key that we're looking for here is for hopefully all the claims to be effectively cleared by the Patent Office examiner. This is called your patent claims being allowed. Your patent can't actually be officially granted until after it's published by the Patent Office, which usually happens 18 months after your first filing date, i.e. your US provisional if you were claiming priority back to that. But the next best thing that can happen, and this is very important from your point of view, is for your patent claims to be allowed, and effectively for your application to be allowed if they consider the description is in good order as well. And once your patent claims are allowed, that effectively means if you get everything done the way you should, and this often requires fairly small amendments, can be a bit more in certain situations, those claims effectively, if everything goes right, are going to go to grant when it comes time for it to be granted. Because we're getting things done so quickly, the UK Patent Office examiner will do what's called a top-up search just around the time of the publication of your application. That's just to check that, for example, when your claims came back clear, it might be that someone else, let's say 5 months ago, had filed a US provisional. It's unlikely, but they might have filed a US provisional, which therefore hasn't been published yet. Now, if within 12 months they file a non-provisional, then when their application is published, if they get the priority of their provisional date, which isn't guaranteed from their point of view, they could actually beat you to the patent. However, this is unlikely. It's a kind of unlikely thing that is fairly uncommon. So if your patent claims get allowed, it's basically an indicator that that patent unless something very unusual happens, is going to go to grant, or those patent claims are going to go to grant. This then opens up several other possibilities. Firstly, that would be great. Second thing, if prior is in the way, as I mentioned, I will tell you what effectively should become your claim 1 or your patenting strategy. If it's advanced things like if prior is found, sometimes you have to split your application into multiple different patent applications. Don't worry about that. I'll explain it to you. I've done that on my inventions, and it's not uncommon. I've gone through that at the UK Patent Office many times before and other patent offices. So I'll explain how that works. But the key thing from your point of view is this. There's something called the patent prosecution highway. The patent prosecution highway is a fairly select party of participating patent offices, one of which is the UK Patent Office, another one of which, and this is important to you, is the USPTO. Another one of which, and this is important to you, is the EPO, the European Patent Office. So if you imagine getting US patent protection and European patent protection, that really realistically is incredible patent protection, very powerful. Whole of the US, the whole of Europe. You've got continental protection. Getting protection in places like Japan, China, India, etc., or Brazil, which is another place some people try, is going to be more complex. But US and European is very possible, especially with the stuff I've got in place right now. And in the future, as I start filing internationally, I'm going to bring stuff into play where you can even go for places like Japan, China, Asia, Brazil, etc. But one of the reasons why the patent prosecution highway is so important is once your claims have been allowed at the UK Patent Office, this is really key here. This is the key, one of the massive selling points of this. Apart from the speed of the LightSpeed patent package, remember only 2 months as opposed to 2 to 3 years. Apart from the price, at the moment $777. One thing I didn't mention about the price, you do also have to pay the official filing fees, which at the UK IPO, it's been very stable for several years now, is £230, which I believe is about $350. Very low, even less than the USPTO official fees for microentity status. The great thing about the UK Patent Office is, like a lot of our things in the UK, it's run non-profit. So unlike the USPTO, which is very fee hungry, the UK IPO, the prices haven't changed for years because they run it in non-profit. They don't try to make any money from it. So very little extra. So that's the prices. So apart from the speed and the price, this is really the key thing, which you can start, a lot of people start to get excited about. You might start to get excited about this possibility with your invention. Once the claims are allowed at the UK Patent Office, via the patent prosecution highway, any of the other participating offices, for example, the USPTO, once you've had these claims allowed here in the UK IPO by the UK Patent Office examiner, the USPTO will accelerate the processing, the search and examination of your application free of charge. In the US, I think it's called expedited. We don't use that term in the UK. We just call it accelerated. And they will do it free of charge. Usually at the USPTO, you have to pay money for this. But they will accelerate it. And sometimes, from what I've seen online, this can mean bringing things down from years to months. And the reason they do that is they effectively use the results of the UK IPO as a very heavy indicator, and to some extent they'll actually get access to and use the results of the UK Patent Office examiner. They'll still search and examine it, but the fact it's been allowed here means the USPTO examiner can go through it with a bit of help, and also it's quite likely they'll allow it too. And this is good from their point of view because it allows them to get this done quicker and streamline their process, which, given that they've got hundreds of thousands of patent applications to go through, is good from their point of view. But the real benefit here is from your point of view. And that package is what we call the US leg. So the first stage, the first step of the LightSpeed patent package is always the UK leg, where we leverage the power, speed and effectiveness of the UK Patent Office, and you leverage Giant Enterprise, my skills, etc. The second leg is what we call the US leg. You can go European if you want, but usually in my experience the best thing is to go UK, US, and I know if you're from the US you're going to want to do that. If you're from the UK you're probably going to want to do that as well, because most of us want a US patent. For a very similar price, in fact I think that the package for the US leg is the same, again $777 only, plus fees, and if you qualify for microentity status, the USPTO fees at current time of speaking are only $400. So for only just over $1,000, remember, going through a patent attorney, just one patent application at one patent office is going to cost you $6,000 to $15,000. And the moment you start moving to other patent offices and start talking to patent attorneys, all communication with me is free, apart from in very exceptional circumstances where I have to do a lot more work. If you start moving to other patent offices, they're just going to charge you more money again, thousands of dollars again. With this, you get it streamlined and you go through this process. Now, as part of that package, the first payment, very much like the last time, $400 first payment. I'll amend the application where it's required, dependent on the results of what claims are allowed in the UK, and dependent on a few other things as well. Conforming your claims to US standards is very important. In the UK, you can do your claims in a certain way. If you file those same claims in the US, doing what's called depending back to all the preceding claims, you end up getting charged thousands of dollars by the USPTO. They have a slightly different payment structure. So I'll amend it where required. The moment it's all ready, I'll then give you this material to allow you to file this application, fully finished as it is, via the USPTO website in minutes. And That will show you how to file your non-provisional. There'll also be other things included, like how to apply via the PPH, the Patent Prosecution Highway, that allows you to get this free acceleration. So again, from your point of view, just massive value. And again, from an inventor's point of view, I know how important that is to you to get all this stuff done so early for so little cost. It's almost unbelievable compared to what's out there. One thing I challenge you to do, go elsewhere on the internet. Go elsewhere to patent attorney, really good patent attorneys, and try to find anything else like this. The moment you get quotes from them, if they quote you anything low like this, as an initial price, just be aware that that's the initial price they charge, and then they're probably going to start charging you thousands of dollars extra as they start having conversations with you over the phone, where you'll get billed about $300 to $500 an hour for those. As the office actions come back from the patent office, they'll then start charging you hundreds or thousands of dollars for their work on an hourly rate. If they charge you a one-off fee, that fee will usually be around $6,000 for a US patent attorney. So look around, and again, remember, you're not sacrificing on quality either, because if your claims are drafted perfectly and you get them allowed, it's a perfect patent. That's an area which I consider my strong point, or something that I really focus very heavily on. And again, although you probably heard me say this before, I've worked personally, I work with multiple actually 3 patent attorneys I'm in contact with right now, who I work together with on various different cases. And again, as you've seen in 7 Deadly Mistakes, the Inventor's making that program, especially in Deadly Mistakes 6, I think, it's not uncommon for me to intercept patent applications which are drafted and filed, maybe even in the process of being prosecuted by patent attorneys, when I notice something is not as it should be. This is not down to lack of quality on the patent attorney. It's just that my skill set is very specific in terms of consumer products, in terms of understanding exactly what the invention is, and I have some added kind of benefits over patent attorneys and patent agents because I'm a professional product designer and user interface specialist myself. And I speak to you about patenting, you the inventor, in a way that we understand. You probably find my stuff much easier to understand, I would hope, than speaking to a patent attorney, who are often very confusing. So there's less breakdown in communication when you work with me, which is really the key thing, which sometimes leads to bad patent applications being drafted. So once you've got the US done, let's hope everything goes well there. What are we going to do next? Well, another thing you've got is LightSpeed, the next leg at the EPO, the European Patent Office. You've already got, hopefully, a UK patent allowed, but the European Patent Office, you can designate various areas and get what kind of European-wide protection for multiple territories. This is a really, a very valuable way to go. Now, the only thing to bear in mind, when you file at the EPO and you file a PCT application, which is a worldwide one to kind of extend your patent pending status, we'll talk about that in a second. The filing fees there are really quite massive compared to at the individual patent offices like the UK and the US. UK only £230, about $350 to get your application searched and examined. US, if you qualify for microcurrency status, only $400, again, really good, unless you filed, I think, more than 5 or 4 non-provisional applications. Certain criteria have to be met for you to get that lower price. The moment you go through the EPO, your filing fees are going to go up. I believe it's like maybe $2,000 to $3,000 or slightly more than that. So this is, the good thing from your point of view is that fee, whilst it seems like a lot, given how much you've saved here, you would have had to spend that fee on your first patent attorney application, just getting a US application. But with this package, with all these savings, if you were to, able to hire a patent attorney before, you're now probably going to be able to go for US and European protection within that budget, and get involved in getting better protection worldwide. So again, a massive value from your point of view. The other thing which is great is the EPO just so happens to be another patent office signed up to the Patent Prosecution Highway. So they will accelerate based on your results at the UK and or the US as well. So another piece of real value. So we're kind of opening all kinds of doors which just haven't been available to you right now. Everything will become clear as you go through the process. I'm here. I'll make sure you're well informed. Last thing I want to mention, PCT applications. This is really just a bit of added information. It's something I haven't filed yet. I've worked on a PCT application of another inventor on one application to do with a medical instrument, but it's something which I haven't got so much information on that I'm providing it yet, but I probably will provide in the future. Filing a PCT application is the gateway to getting more worldwide patent protection. You can't file a worldwide patent. There's no patent office which will allow you to get worldwide patent protection, where you just get one patent granted, it protects you worldwide. It's all done in territories, UK, US, Europe, Brazil, etc., all different patent offices which have to okay your patent. So of course, that's annoying from your point of view, but that's the way it has to be done. There is something called the PCT application though. You have to, if you file a provisional, just like any other patent office, you have to file your PCT application within 12 months of your first application, such as your provisional, especially when you're claiming priority. When you file your PCT application, it is very expensive to file that. Again, the filing fees are quite massive compared to filing at a normal patent office, but it does certain very key things. And this is why this could be important to you. And it could be important to you, by the way, again, especially since you've saved the money on paying a patent attorney for your first application. It extends your patent pending status from 12 months to 30 to 31 months, depending on the patent office. So it gives you huge extended patent pending status within which to file. So normally, after your provisional, you only have 12 months within which to file at all your non-provisional, all the patent offices you want to get a patent at. If you file a PCT within the deadline, that will extend from your provisional. Instead of having 12 months, you now get 30 to 31 months. It depends on which patent office from your provisional. So it goes from a year to basically 2.5 years. This gives you a huge amount of breathing space, and it can be very important to have that time in certain situations. Historically, filing a PCT application was only available to people with massive budget because you had to pay the patent attorney and you had to pay the massive PCT filing fees. With the LightSpeed patent package, it's going to start becoming available to a lot more inventors. I would put that to the back of your mind right now, and I would put UK, US, and Europe to the front of your mind. If you get a European patent granted, it might well be that annuls your UK patent in light of your European patent, because that might effectively get you UK patent protection anyway. But that, just to explain that, the European patent, if it's for the same thing as the UK patent, trumps the UK patent, and the UK patent effectively gets kind of wiped off. You've still got UK patent protection in light of your European patent in that case. But even so, the key to the UK Patent Office, and the key why we start there, is the speed, quality, and effectiveness and price. So that's where we start. All these things are going to become available. I'm going to be releasing a lot of information about things like PCT applications and probably starting blogs where I'm going to explain that stuff to you. Again, the thing which is different from what I provide to anywhere else, I hope as you're experiencing, maybe you find these videos a little bit too much. But what I'm trying to do is put you in a situation where you understand the territory before you step into it. Right? You understand the whole process before you start. Historically, inventors don't know what's going on, both with invention development, product development, and with patenting, and just hope for the best. That's really not where you want to be. With patenting especially, you have to isolate your exact strategy and then execute it. You do not want surprises in patenting. You don't want to, you don't want to have a mentality, let's have a go, let's see how this goes. That might work well in the rest of your life. That will probably get you in a lot of trouble when it comes to patenting. It needs to be strategic, planned, executed. This is something I do. So if this is something you want me to help you with, you like what you're hearing, you like about, the LightSpeed patent package, the Perfect Patent solution, remember it all starts with the Perfect Patent search. You'll see the links below. If you're on YouTube, check on the description below, any links you see on screen. If you're on the Shine Enterprise website, and I'm talking to you personally about this, you should see a link to schedule your free patentability assessment to start the Perfect Patent search. You cannot jump straight to this service without having the Perfect Patent search or Perfect Pending package. The reason for that is that I need to make sure your application is of a proper quality, and I do not want to file something in any way associating my name with it, with a patent application which is imperfectly drafted. And I don't care if you've hired, with great respect, I don't care whether you've hired the best patent attorney in the world. I've seen enough in this industry to know that I need to check that application to make sure it's done right. And even if you hire the best patent attorney, the most expensive patent attorney in the world, my experience is there is a chance which I would have to say is significant rather than minute, that something is not quite as it should be. It's just the whole way this whole industry works right now. There tends to be breakdown in communications and issues happening between inventors and the patenting system. So if you have had your patent non-provisional drafted and you want to use this service without going through the rest of the stuff, you can contact me via the official contact form by going to the navigation bar at the top of this website once you're at Shine Enterprise, clicking on contact, filling out the form. But I'll have to okay everything, and I'll probably have to charge a fee, which will not be a massive fee, but it will probably be up to several $100s, maybe $200 to $300, to go through your application, check it's done right before I decide whether I want to help you with this, because I don't want my name on something or my name associated with something which is not of the highest quality and done extremely well. And what we're really looking for here is to be done perfectly. If you want to move ahead, click on the links below. Let's get going. Let's get this process started. Now you can see the Perfect Patent search, which you may have been considering before. Maybe you already want to go ahead, but now you can see how important these steps are. Each step of the inventor's journey. Of course, the Perfect Patent search and the Perfect Pending package correspond to the first two steps and stage one of the inventor's journey. You get those things out of the way, and if you've got patentable material through that stage and then patent pending status, opens up the whole of invention development. And of course, using the LightSpeed patent package, which at the moment is effectively step 4 of the inventor's journey, you're getting that feedback very, very quickly to make this happen, as soon as it can. Good luck with your invention. If you want to move forward, click on the links and let's get going. And the earliest possible moment that I can speak to you, we'll get that underway. Good luck. Take care.